Welcome to Ignorancia Leges, episode 11, the 23rd of September 2020. Okay, so relax na muli na. We'll continue our discussion. Hopefully, dili kayo saba. And hopefully, my audio is okay. The video is okay. Now, sorry kay late ta nakasugod kay dugay sa ta nakasugod sa. By the way, grabe ning remedial law ha. 3 episodes na tayong nag-discuss and I'm just reciting the topics. Wa pa ta ma-discuss yung topics na. It's taking us 3 episodes just to discuss the topics, the major topics under remedial law. But each of those topics, napagin mga many subtopics with different cases and different principles involved. Mao din na nga remedial law na say 20% weights and is considered the most difficult bar subject. But personally, for me, what will be the most difficult bar subject would be civil law because of its wide coverage, and criminal law because of its strict nature. Like, kung say, diferensya sa robbery, theft, diferensya sa forcible abduction, kidnapping, abuse of superior authority, daghang mga qualifying circumstances ang criminal law. So, ang civil law, because of its wide coverage, ang criminal law because of its very strict elements of the crime, and remedial law, for them, for the others, is considered as the most difficult bar subject. For me, I find it easy. Remedial law, I find it easy actually. That's personal choice. And I remember when I make statements like that, why is JT Benz going against the conventional wisdom? Because that's what I'm actually doing. I'm going against the conventional wisdom sa remedial law. Okay? But yes, the coverage is also wide sa remedial law, and it's procedural law. They call it before procedural law. Si Marcos naka 100% na siguro to sa commercial law, procedural law. Basta ang average sa Marcos sa bar 98.01. Ang iyang bar results 98.01. That's the highest ever. If you question that sa Supreme Court itself, why mo kapag 98.01 niya? Mao man na. Kay, remember, there are many examiners. Di man na yung usarag examiner, may hatag ni mo og 98.01. If there are, for example, 8 subjects, kung ay 8 subjects, there are 8 different examiners. So, they don't know one from the other. They don't know each other. So, when they give the grade, they don't know kinsa ganina kay kung man ang grade. Kanang secret man ang name. So, pag total na, 98.01. Ang lowest grade niya, I think, is 97%. 97. 100, 100, and then 98. And then 97, I think. So, that's the up. No. 100, 197, and I think its lowest grade is 97. The average is 98.01 bar examination. Of course, lately, ang i-recognize nila katong 96% ni Regalado. But katong 96% ni Regalado, para na ko questionable sa to. Because that was the bar when everybody else nagpasa, 73% or something, mo to nakatap sila si Rene Espina, all of those mga people. So, doon ako din hilikid sa itong panahon na. Panahon ni Regalado. Alright, so, bar remedial law topics. Now, unsa may itong ibuhat so far from episode 1 up to episode 11. Naghatag lang ko ninyo og overview sa topics covered under the different laws para is general knowledge for the general public. So, na ding mga unions under na civil law, na separate law na di gitawag criminal procedure, na di gitawag civil procedure, na di gitawag og evidence. Asa nang evidence sabit na nas political law, na nas criminal law, kay evidence man. Di ba? Kung tuog sa nas criminal law. But actually, evidence is in remedial law. Naglibog na tao sa tinuod ni. Okay, and I hope you are there. Asa naman itong chat scene na to. I hope nabina mo din na. Okay. On na ba ta? Nagtingog na ba ta? Streaming na ba ta? Yes. Para mag-uyawan ko ba ta mag-stream? Stream ta. Ganina. Tempa. Sa atong main. Okay. There is sa main. Na microphone. Na piano. Sa chat. Microphone, front microphone, piano. Okay, sige. Right, so I hope ready na mo diha. Okay. Now, for the last 2 episodes magkaisunan, grabe kita. We were just reciting, we were just blurting out the topics. Pila na ka-oras na just blurting out the topics. Sana ka actual pa. So, nahunong ta sa special civil actions. Wow, sa nila guwa mo kasabot unang special civil actions. Na kumanta sa paano ba na siya? Mara bag sulit siya mo nga. Marina. You don't have to understand everything. And the first lesson in trying to learn everything is to get an overview. Maybe I say, okay, I want to learn After Effects, Adobe After Effects. I want to learn OBS. I want to learn Zoom. Akong buhaton, naturo ko sa YouTube, matanaw ko all the OBS videos, tutorials. Tanaw na ko. I don't expect to learn. Tanaw ko, view. So after you view 5 or 10, na naka-idea, ingani, din tayo sa OBS. Sige, mag-download niya ko. Ano ba? Or, magkuhan ka. But it takes time. By the way, it takes time. I spent a lot of time because I was searching for new technologies. Magamit na mo sa mong broadcast. Wala na ko, kini. I don't like this. So, nano ko yung mga technologies in my mind, di pa na mo kinanglan karon, but I'm already studying it. So, akong i-propose na, nga mong i-adapt nga. So, anam-anam na to. All I really do is this. Ang uban, patinta pula na, hasta po na, tutorial, wala. So, you can lead the horse to the water. You cannot force it to drink. So, in this case, parehas ni sa law. Atong inerential leges is, atong tanawon on sa mga topics niya, ang iyang mga topics, atong ikuanan to, muraog, iyang mga topics, atong ihatag niyo as an overview without understanding. Ang imo lang nga, hindi mo concepts ani. And that's how I study also. In fact, the best way to study subjects, for example, na may textbook sa chemistry or algebra or political science, look at the table of contents. Tanawa ng table of content, o saan rin sudan niya, o saan rin yung topics niya. Tanaw kang libro ng trigonometry. Tanawa ang topics, o saan rin topics niya. Just familiar na siya. O saan rin equation of motion, o saan rin rectilinear motion, o saan rin curvilinear motion. So, hindi tanaw mo, na yung mga keywords in your mind. Kaya okay ba, hindi ka na, kaya ba ka na. So, maniton ani mo. Now, sa una, kami magtuon, like law, wa may notes, wa may cases. Ang mga libro sa law library is 3 years old or 4 years old. O niya, daghang manghuwam. Suluoy kay ko, ito ako yung libro. That's why, malipay ka kung papasar ko sa San Carlos. Pasalamat ko sa mga San Carlos professor na naluoy, counselor na ako. Hindi ito akong ipapasar. Diba? Okay, so mana nga ato nang pag-discussion. All right. Si Gigi Bernabe, si Rebecca Gumunares. Rebecca, akong suggestion, please, can you try to go to YouTube right now and then subscribe to our YouTube channel and comment from YouTube. Send a comment to me. I-compare mo ang quality sa YouTube o sa Facebook na signals. This is just an experiment. O si Jovin Pulansad, please, paano siya? Attorney, sorry, Attorney Master, believe ko nimo kay ni President Marcos. Sorry kayo nga kana akong panglantaw. Why? Ang balaod sa una, gamay ra. May hap pa sa tudlo. Kapan karon? Bisan pa tingali 10 GB pa. Gamitan tingali. Di jud maiko. Yeah. Anyway, so but the intelligence of Marcos and what he did during martial law, reconcilable, di ba? So, Jovin Pulan, please go to YouTube, subscribe sa YouTube/SibyaTV, and you watch from there, and you send a comment from there, and compare YouTube versus Facebook. So, tanaw to kasay mas mayong quality. Okay? So, this is the same with Rebecca Monares and Gigi Bernabe and Delia Pardillo. And also, Maybelline Crisostomo, please. Your topic is informative. I hope you can discuss about corporation law, about the SEC, about and ato. Okay, I plan to discuss 30 minutes. Ato nang imurang ikuan ba i-follow sa bar exam. 30 minutes sa political law, 30 minutes sa labor. Now, remember, ang law is 4 years. So, 4 years at mo discuss ni. Si Ramer Reyes. Ramer, can you go to YouTube? Natutanaw Ramer Reyes sa YouTube, watching from Tracy Martinez Cavite. YouTube tanaw, comment in YouTube and send the comments to me, and tanaw na to on-site quality sa inyong discussion. Sa quality sa audio o video. Atong discussion maklaro ba dito. Okay? So, mana ito mga and please, also Maybelline also. Si Consing Ibanez, please also Consing, go to YouTube and send your message from there. Asay mas maayong quality, YouTube or Facebook. Everybody. Okay. So, nakadiscuss na sa special proceedings, karon nga nata sa special civil actions, ngaron nata sa criminal procedure. Unsa man ang criminal procedure? Atong discuss is civil procedure and criminal procedure. Now, sa tuon lang, mas grabe itoon sa civil procedure because practically civil procedure is the standard. Ang criminal procedure, specialized procedure regarding crimes and punishment. This is how to enforce now the law and how to defend yourself in the law. So, criminal procedure may nga na topic. Procedure. So, this is a part of remedial law. Sa una, ang nga ng remedial law, procedural law. O unsay mga topics aning procedural law. Criminal procedure. General matters. Distinguish jurisdiction over subject matter from jurisdiction over the person accused. Requisites for exercise of criminal jurisdiction. Jurisdiction of criminal courts when injunction may be issued to restrain criminal prosecution. Okay. So, prosecution of offenses, criminal actions, how instituted, who may file them, crimes and cannot be prosecuted de officio. So, na crimes nga dili ma-prosecute de officio. Ano sa mga kanang mga private crimes? Mga rape? Kuan? Acts of lasciviousness? Ano sa man? Sa may mga kuan na dili mag-kuan de officio. Criminal actions when enjoined, control of prosecution, sufficiency of complaints or information, designation of offense, cause of the accusation, duplicity of the offense, exception, amendment or substitution of complaints or information, venue of criminal actions, intervention of offended parties. So, may mga subtopics niya. Prosecution of civil action. Rule, kay ang criminal action na po siya civil action. prosecution of civil action, rule on implied institution of civil action with criminal action, when civil action may proceed independently, when separate civil action is suspended, effects of the death of the accused or convict on civil action. So kung mamatay na before na convicted siya, or na convicted na siya, namatay siya, on some effects sa civil action ning claim mag damages, di na tumayad og damages, namatay wala bayad sa utang. Question na, prejudicial questions. So can prejudicial question ini bar exam ani mabuang gyud gani. Rule on filing fees in civil action deemed instituted with a criminal action. Preliminary investigation, nature of right, purposes of preliminary investigation, who may conduct, determination of existence of probable cause, distinguish executive and judicial determination of probable cause, resolution of investigation, prosecutor review, when may warrant of arrest may issue, cases not requiring a preliminary investigation, remedies of accused if there was no preliminary investigation, and inquest. Sa may diferensya ng preliminary investigation ug inquest. Arrest are made, arrest without warrant when lawful, method of arrest, by officer with warrant, by officer without warrant, by private person. Now, requisites of a valid warrant of arrest, determination of probable cause for issuance of warrant of arrest, bail, nature, when a matter of rights, exceptions, when a matter of exceptions, hearing of application for bail in capital offenses, guidelines in fixing amount of bail, bail when not required, increase or reduction of bail, forfeiture and cancellation of bail, application not a bar to objections in illegal arrest, lack of or irregular preliminary investigation, arraignments and plea, how made, when should plea of not guilty be entered, when may accused enter a plea of guilty to a lesser offense. Accused plead guilty to capital offense, what court should do, searching inquiry, improvident plea, motion to quash, grounds distinguish from demurrer to evidence, effects of sustaining the motion to quash, exception to the rule that sustaining to the motion is not a bar to another prosecution, double jeopardy, provisional dismissal. So, kanalang double jeopardy daan, grabe na. Pre-trial, instances when presence of accused is required by law, requisite before trial can be suspended on account of absence of witness, trial in absentia, remedy when accused is not brought to trial within the prescribed period, requisites for discharge of accused to become a state witness, effects of discharge of accused as state witness, demurrer to evidence. So, kanin demurrer to evidence, by the way, magawas nga ni Sbar, demurrer to evidence in criminal cases, demurrer to evidence in civil cases. Importante ka na. Guidelines on continuous trial applicability, prohibited and meritorious motions, arraignments and pre-trial, trial memoranda, promulgation, judgment in criminal actions, requisites of a judgment, contents of judgment, promulgation of judgment, instances of promulgation of judgment in absentia, instances when judgment becomes final, new trial or reconsideration, grounds for new trial, grounds for reconsideration, requisites before a new trial may be granted on ground of newly discovered evidence, effects of granting a new trial or reconsideration, appeal, effect of an appeal, where to appeal, how appeal taken, effect of appeal by any of several accused, grounds for dismissal of appeal. Now, search and seizure. Nature of the search warrant, distinguish from warrant of arrest. So, lahi ng search and seizure warrant, lahi po ng warrant of arrest. Actually, ang search warrant is more difficult than arrest warrant. Ang conditions niya, mas lisod ang conditions sa search warrant. Kaya kanang warrant of arrest, mura mag nakakommit na kag crime. Ang katong search warrant, wa man kay crime. So, i-search imong house, i-search imong auto, mas dapat mas stricto na, kay mas grabe na sa source of harassment. Probable cause of issuance for search warrant, personal examination by judge of the applicant and witnesses, particularity of place to be searched and things to be seized. Ayay, kung apartment number 1, apartment number 2, hindi na pwede ha. Unless na gitawag plain view doctrine. Makita nimo in plain view nga na contraband diya. Personal property to be seized, exceptions to search warrant requirement, search incidental to lawful arrest. You cannot be arrested and then search. First, there must be a search before arrested. Search incidental to lawful arrest, consented search, search of moving vehicle, checkpoints, body checks in airports, plain view situation, stop and frisk situation, kanin Dateri versus Ohio doctrine, Dateri doctrine, enforcement of custom laws, remedies from unlawful search and seizure, cybercrime warrants, scope and applicability, general provisions, preservation of computer data, disclosure of computer data, interception of computer data, search, seizure, and examination of computer data, custody of computer data, destruction of computer data. Provisional remedies in criminal cases. So, kana lang daan provisional remedies in criminal cases. Taas na ka topic. Now, let's move on to evidence. Okay. Time pa. Tano to siya yung mga messages makaigsunan. Si Jennifer Ricarte, good PM Kuya GT. So, Jennifer, try ko no move to YouTube. Asay mas mayo quality. Yeah. Please send me comment dito sa YouTube. The same with Joy Formentera. Namina po na ito ron. O ni Angelo Fuentes. May hapon ito ni di karon sa Manila. Unya dito ko gahapon sa Tugo kay lukat unta kong ticket. Wala man may kitagaan kay pangayo an may acceptance sa barangay sa Cebu. Unya ang kapitan dili daw pwede ipanghatag ang acceptance. Okay, Angelo ha, di ko ka kuan ani sa may expert ani ha. Nagkag-contact sa barangay captain si John Perez siguro mas mayo ani. Kay aron mapangutan nila sa barangay captain. Okay, sorry kayo kay ako'y wala na experience na. Okay. So, narita sa evidence. Kaya evidence na po sa part sa samantan kadaghan ng balaura. Maglibog naman ta. Mahuman pagkatag pila ka oras ani. Balik upat mas ka oras siguro itong just reading out. Just discussing the topics. Ang kuan na ni makaigsunan ang let me see. Tanaw na to ha. Okay. Now, evidence. Narita sa evidence. General principles, concept of evidence, scope of the rules of evidence, distinguish proof and evidence, distinguish factum probans and factum probandum. Probandum na ultimate facts. Okay. Admissibility of evidence, requisites for admissibility of evidence, exclusions under the Constitution, laws, and the rules of court, relevance of evidence and collateral matters, multiple admissibility, conditional admissibility, curative admissibility, direct and substantial evidence, positive and negative evidence, competent and credible evidence, burden of proof and burden of evidence, presumptions, conclusive presumptions, disputable presumptions, presumptions in civil actions and proceedings against an accused in criminal cases, construction of the rules of evidence. Again, construction means interpretation. Quantum of evidence, judicial notice and judicial admissions. What need to be proved, matters of judicial notice, mandatory, discretionary, judicial admissions, effect of judicial admission, how judicial admissions may be contradicted, pre-trial admissions, object of real evidence, nature of object evidence, requisites for admissibility, categories of object evidence, chain of custody in relation to Section 21 of the Comprehensive Drugs Act of 2002, DNA evidence, meaning of DNA, application for DNA testing order, post-conviction DNA testing, remedy, assessment of probative value of DNA evidence and admissibility, rules on evaluation of reliability of the DNA testing methodology, documentary evidence, meaning of documentary evidence, requisites for admissibility, the original document rule, meaning of the rule, when not applicable, meaning of the original document and duplicates, secondary evidence summaries, electronic evidence, meaning of electronic evidence, electronic data message, provable value of electronic documents or evidentiary weight, method of proof, authentication of electronic documents and electronic signatures, electronic documents and the hearsay rule, audio, photographic, video and ephemeral evidence, parole evidence rule, application of the parole evidence rule, when parole evidence can be introduced, distinguish original document rule and parole evidence rule, authentication and proof of documents, meaning of authentication, classes of documents, when a private writing requires authentication, proof of private writing, when evidence of authenticity of a private writing is not required, genuineness of handwriting, public documents as evidence, proof of official record, attestation of a copy, public record of a public document, proof of lack of record, how a judicial record is impeached, proof of the notarial documents, alterations in documentary evidence in unofficial language, testimonial evidence, qualifications of a witness, disqualifications of witnesses, disqualification by reason of marriage, disqualification by reason of privileged communications, rule on third parties, husband and wife, attorney and client, exceptions, physician and patient, priest and penitent, public officers, parental and filial privilege rule, trade secrets, examination of a witness, rights and obligation of a witness, order in the examination of an individual witness, leading and misleading questions, impeachment of witness, adverse parties witness by evidence of conviction of crime, own witness, how the witness is impeached by evidence of inconsistent statements, referral of witness to memorandum, examination of a child witness, applicability of the rule, meaning of child witness, competency of a child witness, examination of a child witness, live-length TV testimony of a child witness, videotape deposition of a child witness, hearsay exception in child abuse cases, sexual abuse shield rule, protective orders, admissions and confessions, admission by a party, res inter alios acta rule, admission by a third party, admission by a co-partner or agent, admission by a co-conspirator, admission by previous, admission by silence, confessions, similar acts as evidence, admissibility of offers of compromise. The hearsay rule, meaning of hearsay, reason for exclusion of hearsay evidence, exceptions to the hearsay rule, dying declaration, statement of dissident or person of unsound mind, declaration against interest, acts or declaration about pedigree, family reputation or tradition regarding pedigree, common reputation, part of the res gestae, records of regularly conducted business activity, interest in official records, commercial lists and the like, learned treatises, testimony or deposition at a former trial, residual exception, independently relevant statements. The opinion rule, opinion of expert witness, weight given, opinion of ordinary witness, character evidence, criminal cases, civil cases, criminal and civil cases, judicial affidavits, scope, submission in lieu of direct testimony, contents, offer an objection, application in criminal cases, effect of non-compliance, offer an objection, offer of evidence, when to make an offer, objection, repetition of an objection, ruling, striking out of an answer, tender of excluded evidence. Revised rules on summary procedure. Cases covered by the rule sa summary procedure niya. Effects of failure to answer, preliminary conference and appearance of parties, prohibited pleadings and motions, and appeal. So, imo gining memorize ning prohibited pleadings and motions sa RSP, Rules on Summary Procedure. Katarungang pambarangay, cases covered, subject matter for amicable settlement, venue, when parties may directly go to court, execution, and repudiation. Now, kining katarungang pambarangay, kining mga kanang sa atong pas barangay bitaw. So, ang exceptions imong memorize na. Rules of procedure for small claims cases, scope and applicability of the rule, commencement of small claims action, response, prohibited pleadings and motions, appearances, hearing, duty of judge, and finality of judgment. Rules of procedure in environmental cases, scope and applicability of the rule, civil procedure under environmental cases, provision against temporary restraining order and preliminary injunction, pre-trial conference, consent decree, prohibited pleadings and motions, temporary environmental protection order, judgment and execution, relief in a citizen's suit, permanent environmental protection order, writ of the continuing mandamus. Magawas kinasbar ng continuing mandamus. strategic lawsuit against public participation. Kaya strategic lawsuit, magawa sa nagbar. Special proceedings, writ of kalikasan, prohibited pleadings and motions, discovery measures, writs of continuing mandamus. Criminal procedure, who may file, institution of criminal and civil action, arrest without warrant, when valid, procedure in the custody and disposition of seized items, bail, arraignment and plea, free trial, subsidiary liabilities. Evidence, precautionary principle, and documentary evidence. That's all under environmental cases. Now, ngaritas alternative dispute resolution, hopefully mananilast. Alternative dispute resolution, types of processes and procedures in alternative dispute resolution, comparison with court annexed mediation, domestic arbitration, judicial review of arbitral awards, appeal from court decisions on arbitral awards, venue and jurisdiction, special roles of courts on alternative dispute resolution, subject matter, summary proceedings in certain issues, prohibited submissions, judicial relief involving the issue of existence, validity and enforceability of arbitration agreements, interim measures of protection, enforcement and recognition, or setting aside of an international commercial arbitral award, recognition and enforcement of a foreign arbitral award, and special civil action for certiorari. So kana in the last 3 episodes mga kaigsaran, nag-discuss rata, nag-recite rata sa subtopics. Each subtopic, dagan pa nag-additional topics mga kaigsaran, dagan thousands of cases na imong studyhan for the bar. Remember, ang bar, dili pa nga what is this procedure, what is that provision. Case na siya. Alright, so salamat sa pag-uban ka na ako and sa inyong mga messages. Si Fipanya Palingkod, hello SibyaTV, Cristita Saraum, okay raka sa YouTube, and si Norma Romarati. Again, try to ngato mo sa YouTube tanaw, ngato mo subscribe sa YouTube, nya tanawa makaigsunan ang YouTube og asay better quality, nya asay mas nindot pagpangita sa mga previous nga mga episodes nato. Mas dali ba sa Facebook or mas dali pa sa YouTube? Share with us your actual experience and view sa YouTube atong previous episodes o kaning episode, asay mas nindot, mas dali ang YouTube or ang Facebook. So that will also help us determine. Although na-broadcast simultaneously sa duha, ang akang nabantayan Facebook, grabe kayang delay. Ang sa YouTube, dili kayo, short run delay. Thank you and good afternoon. Kini ang episode 11 sa Ignorancia Leges. Salamat sa mag-over ka na ko magkaigsaran. Kini si JT Vance sa Ignorancia Leges. Night. Good afternoon.